Good morning and good afternoon, everyone. Thank you for joining us for today's webinar on supporting transgender and gender diverse employees in the workplace. Erin Porter had an emergency and unfortunately is not able to join us to moderate the session today, so I will be both your moderator and speaker. While I introduce Grace and myself, please see the information slide that is on your screen. I draw your attention to the survey piece. We really value your feedback on these sessions and encourage you to fill in the survey before you log out of the webinar today. We're also happy to announce that we are debuting an automatic CPD certification process at our webinar today. At the end of the presentation, we'll have two options for you to automatically receive your Ontario or Quebec CPD certificate. A QR code will appear on the screen, or you can use the link that is added to the audience chat. So it's my pleasure to introduce my Labor, Employment, and Human Rights colleague, Grace McDonell. She is an associate in our Toronto office. Grace regularly assists clients on equity, diversity, and inclusion issues and initiatives, as well as their litigation needs. Grace is a member of the Fasken firm-wide Equity, Diversity, and Inclusion Committee and co-vice chair of our Fasken Pride Network. She's a former director of the Canadian Bar Association Sexual Orientation and Gender Inclusion Committee of the BC branch. Turning over to myself, I'm a partner in our Ottawa office. I focus on management side labor and employment law. I advise clients on matters including employment standards, wrongful dismissals, employment contracts, injunctions, labor arbitrations, labor conflicts, negotiations, and human rights. So we're going to move on right away to our first slide. And first, I really want to say that I'm quite pleased to see that there are so many of you joining us on the line for this important topic. The statistics show that more than half of transgender employees say they're not comfortable at work, and they report feeling less supported by their managers. So today we want to take some time to review some best practices you can consider when it comes to providing support for these employees, and also some lessons that we're going to learn from the recent decisions. Before we do that, Grace is going to review some background and terminology, and also some key principles and consideration when it comes to collecting data and dealing with employee privacy concerns. Before we get started, I can quite candidly share with all of you that there's really often no one-size-fits-all approach to these topics that we're discussing today. We all continue to learn in this evolving area of the law. So be patient with yourself and tell yourself that just by being here today, it shows that you're engaged in taking some positive steps towards a better understanding of some of these issues. In fact, we hope that if you're here with us today, it's because you're eager to get engaged in providing transgender and gender diverse employees the support that they need. From our point of view, it's simply the right thing to do. But it also helps your organization to be in a bit better position to respond to challenges, win top talent, and meet the needs of different customer bases. Indeed, if you fail to adopt these trans-specific policies and practices, it can cost your business dearly in the form of higher turnover, decreased engagement and productivity, and as we're going to see from our presentation, it can also lead to some litigation. So Canada's population is changing according to Statistics Canada, and a study from Pew Research Center found that workers under age 30 are the most likely age group to say that focusing on EDI at work is a good thing. About 2/3, so 68% of those workers aged 18 to 29 say that this is so. So it's easy to see how this trend is going to continue to grow as these demographics take on a larger part of the workforce. But supporting transgender and gender diverse employees is not only the right thing to do and good for your organization, but it also stems from legal requirements. And I hand it over to Grace to start with these legal requirements that apply.
Thanks so much, Judith, and thanks for pulling double duty today, moderating and being a panelist. Like Judith said, my name's Grace McDonell, and my pronouns are she and her. As we move into our background and terminology, it's important to recognize that legal obligations and this terminology are truly the backdrop, and it's what we really need to turn our minds to before we can get into discussions around best practices as well as the case law. So moving into the next slide, human rights legislation. In every Canadian jurisdiction, employers have an obligation to provide employees with a workplace free from harassment and discrimination based on protected grounds. So, for example, in Ontario, harassment is defined in the legislation, along with many other provinces, as being the means, engaging in a source of vexatious comment or conduct that is known or ought to reasonably be known to be unwelcome. Now, employers are required to investigate as part of the employer's general duty to ensure that its workers are not exposed to harassment and discrimination in their workplace. Now, in terms of gender identity and gender diversity and inclusion, when exactly did these obligations come into play? So in around 2012, for the Ontario Human Rights Code, that's the year it was amended to add gender identity and gender expression. Now we're going to talk about this in terms of terminology, but they are two separate things. In 2017, from a federal national perspective, the Canadian Human Rights Act was amended to protect gender identity and gender expression. Now, this protects individuals whose gender identity or expression is or is seen to be different from their birth sex. So in Ontario, this was mentioned in the case law in a case of Brown and Sudbury Integrated, where, as stated, the code was amended in 2012 to add gender identity and gender expression as protected grounds through legislation known as Toby's Act. The purpose of adding these grounds to the code was to address a perceived gap in the protection afforded to transgender and other gender nonconforming persons. So it was essentially considered a perceived gap because it didn't actually exist. However, in the case law, as these instances came up with, trans employees or people trying to access services, basically the courts and the tribunals lobbed it under the protected ground of sex. And as we know, that doesn't necessarily fit the definition, or as we'll come to learn, that doesn't necessarily fit the definition of being gender diverse or trans. So the governments across the country and federally said, we need to add some new protections here. So that's where gender identity and expression came to play. One thing we'll be talking about today is how that looks like, or what that looks like. And it's important to remember that traits are an expression of gender. So moving along now, we also have occupational health and safety legislation. So under the various provincial and federal occupational health and safety regimes, employers have a duty to the following: to take all reasonable precautions, have a policy, train employees, investigate complaints. And we also have incidents here, right? We'll talk about some case law today where, sometimes, there's someone who has potentially been a victim of something or alleged victim of something. And the employee is obligated to not just look into complaints, but if someone doesn't want to necessarily bring something forward and the employer still becomes aware of, that would be considered some type of incident that employers are still required. They have a duty to investigate incidents or the potential that an incident has occurred. As well as finally report findings. So those are just a couple general points with respect to the legislation. You have your human rights legislation, can be provincial, can be federal, as well as this occupational health and safety legislation. So moving on, if we really dig in deep as to what potential issues we're talking about today, they involve harassment and toxic work environment. So an employer may be responsible for, as showcased in the case authority, incidents that occur off the employer's premises, incidents that occur outside of working hours, incidents that occur between an employee and a third party, and we have big flashing letters new, potentially outing an employee to members of the public. Now, we're going to bookmark that one. That one might be a little new for everyone. There was a recent case in September, which we'll get to at the end of our presentation. So that's the backdrop in terms of legislation. The things that we want to be thinking about in our workplace and in our environments is harassment, discrimination, creating a toxic work environment. Moving on to terminology, and then a little asterisk that I always like to add, because as Judith said, a lot of these concepts are ever changing, ever evolving. Judith and I are both constantly keeping ourselves and each other's up to date on new terminology, and just making sure that we're staying educated just on our own. And then, of course, we want to be educated in our workplaces as well. So a lot of these definitions are provided by the Government of Canada. It's a terminology that they use. So oftentimes a safe bet with respect to keeping things consistent, as well as a lot of these terms have been furthered by the academia as well. So let's just go through them because, as Judith mentions, it's important to know what we're talking about here today. So 2S LGBTQI+, you might have heard a number of different versions of this term. It's the acronym used by the Government of Canada to refer to the Canadian community. 2S being at the front, very important to keep it at the front, recognizing the Two-Spirit people as the first 2S LGBTQI+ communities. L for lesbian, G for gay, B for bisexual, T for transgender, Q for queer, I for intersex, considers sex characteristics beyond sexual orientation, gender identity, and gender expression. The plus is inclusive of people who identify as part of sexual and gender diverse communities who use additional terminology. So we're leaving it open. We want to be overly inclusive. Always good to keep the plus. You may see the 2S LGBTQI+ shortened. The long version is always good to just add on the plus. It's a sign of inclusivity. And I know we often refer to it sometimes as the alphabet soup. It can be a lot to say for sure, but once you say it a couple times, it kind of just rolls off the tongue to LGBTQI+. Next, moving on, we have SOGI. I know a lot of us have heard this term, sexual orientation and gender identity and expression. It can be SOGI, SOGI, SOGIC, SOGIA. There are also a number of different versions of that. However, they all necessarily mean the same thing. Two-Spirit, which we mentioned before, or Two-Spirited. It's a term used to broadly capture concepts traditional to many Indigenous cultures. It is a culturally specific identity used by some Indigenous people to indicate a person whose gender identity, spiritual identity, and/or sexual orientation comprises both male and female spirits. Okay, we're going to move on here. Cisgender is a person who identifies with the gender they were assigned at birth. So, for example, if they were assigned female at birth and they identify as female, that would be considered someone who's cisgender. Just to note, it's not a derogatory term to refer to someone who is cisgender as cisgender. It's more of an academic defined term. Gender fluid, a person whose gender identity varies over time and may include male, female, non-binary gender identities. It's a good, safe kind of umbrella term, and you'll hear us use the concept of umbrella term a couple times today. We also have intersex, speaking of an umbrella term to capture various types of biological sex differentiation. Intersex people have variations in their sex characteristics, such as sex chromosomes, internal reproductive organs, genitalia, and/or secondary sex characteristics, muscle mass, breasts, that fall outside of what is typically categorized as male or female. Moving on, we have non-binary, often referred to as well as genderqueer, another umbrella term, referring to a person whose gender identity does not align with a binary understanding of gender, such as man or woman. It is a gender identity which may include man or woman, androgynous, fluid, multiple, no gender, or different gender outside of the woman-man spectrum. We also have gender dysphoria, which is used as a medical term or diagnosis required by health providers and/or health insurance plans before prescriptions for hormones or gender-affirming surgeries will be provided. It can be understood as discomfort or distress experienced by a person who feels their sense of gender identity differs from their body based on societal expectations. So not everyone who may be gender diverse or trans experiences gender dysphoria. There's also a term opposite to that called gender euphoria, which means, you're feeling good, content, happy in your body and the way that you're expressing yourself. And that's often a very good sign that there's a safe environment for that person. Moving on again, gender expression refers to the various ways people choose to express their gender. Oh my gosh, the list is endless. It could include clothes, voice, hair, makeup, nail polish. A person's gender expression may not align with societal expectations of gender. It is therefore not a reliable indicator of a person's gender identity. So this is important. So gender identity being internal and deeply felt sense of being a man or a woman, both or neither. A person's gender identity may or may not align with gender typically associated with their sex. It may change over the course of one's lifetime. So these can be two separate things. How you identify and how you express yourself can be totally different, right? We can think of a lot of things such as, historical stereotypes, like only girls wear nail polish. Well, you can identify as any gender and express yourself in any way, nail polish included or excluded. Transgender, also referred to as trans, an umbrella term, a person whose gender identity differs from what is typically associated with the sex they were assigned at birth. We want to give just a quick note on terms no longer used or that many of us, depending on how we identify, should not be using. In a lot of cases, they can be considered inappropriate or disrespectful due to their historic negative connotation. So things we should just avoid saying in the workplace. Homosexual is not a term that's used very frequently anymore and shouldn't make its way into the workplace, as well as transsexual or in any and all of its forms, or oftentimes abbreviations as they become derogatory. So moving on, that's where we I know it's a lot of information, a lot of different terms, maybe a lot of new terms as well. Like Judith said, we're all in the process of learning and educating ourselves. But I think it's important to jump into, now that we know a little bit of what the community is comprised of, is why we're here today. And Judith also launched into it as well, but I want to give a quote from a 2023 Supreme Court of Canada case called Hansman and Neufeld that really solidified, why it is very important to support transgender and gender diverse employees in the community. The court said, the transgender community is undeniably a marginalized group in Canadian society. The history of transgender individuals in Canada has been marked by discrimination and disadvantage. Transgender and other gender nonconforming individuals were largely viewed with suspicion and prejudice until the latter half of the 20th century, and have been stereotyped as diseased or confused simply because they identify as being trans. Significant legal advancement in transgender rights have only come in the last 35 years, with most change taking place in the last decade, and judicial recognition of the plight of transgender individuals in Canada is growing in the wake of legislation as well. Yet, despite some gains, courts and tribunals have recognized that transgender people remain among the most marginalized in Canadian society and continue to live their lives facing disadvantage, prejudice, stereotyping, and vulnerability. I think it's important to note that we could spend this whole time, and honestly this whole day and the rest of the week, talking about the statistics with respect to what the transgender community faces at work, in the medical community, outside, walking around the streets in their day-to-day lives. But I think that quote solidifies it very well. So there are, like I mentioned, obviously barriers then faced by the community. It was only just a couple years ago that Canada actually became the first country to provide census data on trans and non-binary people. So before that time, we didn't have any stats. And we didn't have any stats until 2021, which showed that 0.2% of the population identified as being trans. However, 62% of that are younger than 35. So it obviously affects, at least in 2021, the younger generations, or I should say my generation, as well. So, and this was also exacerbated by COVID-19. There was a number of reports that said that COVID-19 had a significant impact on the working likes of two-spirit, transgender, gender diverse community members through job loss, cut hours, and childcare responsibilities. And even if you need a bit more information to really move the needle here. One of the main points being that a TransPulse survey found that 24% of trans people have an annual income of under $15,000. Counterpart to that, people who identify as lesbian, gay, or bisexual have an average annual income of $39,000. And then if we move to their heterosexual counterparts, that's 58,000 people, and that's from Statistics Canada. So the medium or the annual average income, heterosexual people, 58,000, people who identify as trans, 15. So that's a very big gap. And then moving on from that aspect, in 2022, police reported hate crimes jumped from 27% overall. So hate crimes against members of the 2S LGBTQIA plus community jumped by 64%, and that's from Stats Canada as well. So we kind of just wanted to provide this backdrop just to solidify that there are significant barriers. There is or has been differential treatment. And these are things that, we can focus on alleviating or trying to alleviate within the workforce. Just moving on to the next slide. So recently, the Employment Equity Act Task Force released their findings. This was in the fall of last year. And they also found that discrimination, harassment, and exclusion were found to be prevalent within the transgender community, and barriers at hiring were substantial. A couple more stats here in terms of 30% of transgender women reporting that they had been denied employment due to their gender identity. So despite this progress and the fact that we've only really started collecting this data since 2021, we're still in the process of getting, the difficulty of getting accurate data on employment. It's been a significant challenge. It's therefore not yet totally possible to understand just how bad, perhaps, the employment context for trans or gender diverse employees is in the absence of large data. So I bet you're sitting there wondering, but how do we then figure this out, Grace? How are we supposed to help? How are we supposed to figure out what we need to do in our work environment? So we're going to move on to the next section, which is data collection and privacy considerations. So our mantra for this section and for data collection in your businesses is it should be done reasonably and for a justifiably expected purpose. So it can be tricky, as mentioned, for transgender employees given the risk of outing. So I'm just going to kind of walk us through the process. We can move on to the next slide. Collection of EDI data as well. These are different considerations for each aspect of the employment journey. So we have pre-employment, which, you're going to be probably seeking less data and less information at that stage, given that there isn't an established employment relationship. Then we have during employment, and then, of course, after employment. So in terms of the different considerations, then we also have different legal requirements for employers. So you might be a federally regulated employer, which means you're under the Employment Equity Act. I'll talk about that a little bit. You may also be required, even if you're not a federally regulated employer, you may be covered under the Federal Contractors Program. So you might have to provide EDI data to the Labor Board or to the Labor Program. As well, there are for sure considerations if you're provincially regulated. We'd ask that you consider it and for if you are provincially regulated. So the task force, basically for the Employment Equity Act, recommended that employers should be adding 2S LGBTQIA+ as a separate group for data collection. So that specifically means in the next couple of months, perhaps year. I don't have a magic ball, unfortunately. We expect the legislation to be changed so that in addition to collecting data about women, as well as indigeneity, you will need to add questions for your 2S LGBTQIA+ workers. Next slide. So for provinces without some type of private sector privacy legislation, there are no formal requirements regarding the collection, use, and disclosure of this information. The best practices should generally be followed to minimize potential concerns or complaints being asked for this information. So this means typically aligning privacy practices with provinces that do have private sector legislation to ensure a consistent approach. And this will be to minimize differential treatment between employees. So best practices for provinces that have private sector legislation, which are Alberta, BC, and Quebec, and this is very important, collecting information only on a voluntary and anonymous basis. The biggest key. Limiting information collection to only what is considered essential for your policy or for what you want to do with that information, and providing notice to the employees and job applicants, if collected at that time, regarding how and what the purpose of the info will be, and that includes how it is to be collected, the manner in which it is to be used, the manner in which, if at all, it is to be disclosed, and who has access. So those, I'm going to say them again, they're the 4 core principles. How data is collected, how it's used, how it's disclosed, and who has access. So the main thing being, as I mentioned, on a voluntary, anonymous basis. There are some, considerations to be made. For example, typically, if you're going to try to get aggregate data, you can put a policy, generally speaking, that if there's less than 5 answers, we won't turn that into aggregate data because that could risk outing someone or being able to identify them. So we recommend as a best practice, including the, basically your questions for data collection where do you identify as male, female, gender diverse, but not putting other in the same line as gender diverse. Sometimes we see gender diverse or gender non-conforming / other. That has a tendency to be trying to other that person. So if you want to do an other box or just a blank box where people can fill it in, that would be our recommendation, is to allow people to provide that space. Once again, under the umbrella of this is completely voluntary for you to fill out. And the second thing being, it's going to be completely anonymous as well. So moving on to manage data risks. Once again, I said the anonymization and aggregation, data minimization, data protection, storage, safeguards, access, and then transparency for how that's done. So having best practices in place when collecting data can alleviate certain risks. So to the extent that any information can be linked to identifiable individuals, ensuring that this information is only kept for as long as necessary to fulfill its purpose and then securely destroyed. Aggregate anonymized information such as statistics on workplace diversity is not subject to the same concerns exactly. Information should only be disclosed outside the business on an aggregate and anonymized basis. So that's what we were just talking about in terms of making sure you have the right number of responses before you produce that data. So steps taken to appropriately safeguard personal information. You want to keep the information separate from the employee's personnel file and ensuring it is only accessible on a confidential needs-to-know basis. So this is not in their employee file, not in any way that could be identifiable to them, completely separate with the rest of your data. And once again, it should only be accessible to those who require access to it, and should always be protected by password or other means. So the more safeguards, the better with respect to liability. So it's not just in a drawer and you can easily open it and anyone can walk into the room and take a look. Another key principle here in terms of managing data risks is honesty, transparency, and consent. So where employees know why data is being collected and how it's being used, employers are better protected from claims of improper use. If you're able to say, for example, that we have a special program, it's been approved or is pursuant to a commission's guidance, like the Human Rights Commission, or it's pursuant to the Human Rights Code with respect to special programs, and we're collecting that data for that reason, it's a good argument for the collection and use of the data. So for example, if you say, we've looked at our data, or we want to collect our data because we want to make sure that we have a diverse workforce. We want to make sure we're hiring, equal numbers from every group. And sometimes it's not always, possible to hire equal numbers from any historically disadvantaged group. However, if you say, we're really wanting to think about this and this is why we're collecting that data, that's a safe reason to be collecting that data, is to say, or, we want to be able to understand what our workforce looks like because we might need to implement some policies. And at this time, we don't know what our workforce looks like exactly. We want it to be diverse, but we don't know how to respond and what needs our employees might have with respect to policies or training. So we need to collect this data. That's also having that very clear policy statement, writing it on the survey itself. So that wraps up data collection and privacy. And Judith, I'll toss it back to you.
Wonderful. Thank you so much, Grace. Lots of information there. And we do want to move on to practices that you can consider to better support your gender diverse and transgender employees. In doing that, if we move on to the next slide, we need to take a step back and consider some important EDI concepts. that really deal with bias, stereotypes, and microaggressions. So our biases, what are they? There are opinions that we form based on our personal experiences, what we hear from others, whether they're our friends or on social media or in the news. It's institutional influences, it's our culture, and it's our upbringing. There are some explicit and implicit biases, but an important bias that we often hear about in this context is unconscious bias, and you'll be familiar with that. This type of unconscious bias can be difficult to address because it's not deliberate and it's not intentional. We really often don't even realize we're making unfair assumptions about others, and it's important that we're reminded, to really pause and consider whether our own conduct or judgment is being affected or influenced by our unconscious bias. So there's a whole bunch of different unconscious biases. One is affinity or performance bias. And in that case, we may be prone to believe, or even favorably evaluate those with whom we have an affinity. There's confirmation bias. In that case, our interpretation of the information that we receive is influenced by what we already think happened. And it also affects how we remember the information that we receive in what is essentially called selective memory. So stereotypes we also need to think about because they can lead to differential treatment or scrutiny that's related to gender identity or expression. And they're not expressly recognized in human rights legislation, but really, in the end, they often manifest themselves as discriminatory conduct. So this can occur through either signs or statements or employment practices that really have an adverse effect on certain individuals. The biases that we have and the stereotypes that we have can lead to some microaggressions. And these microaggressions can be experienced as homophobia and transphobia, and can certainly make a workplace feel uncomfortable, unsafe, and toxic. What's key is that, again, people are unaware that they've engaged in these microaggressions and that they've engaged in a way that's really offensive and demeaning. It's little things that are said and done, and it's hard to stop doing something when you don't know what you're doing is inappropriate or really actually constitutes a microaggression. So again, it's important to take some time to reflect on what we say and how we say it. Examples of microaggressions can be something like, your voice doesn't match you, or, oh, you don't sound like I thought you would. It can include commenting on clothing, on jewelry choices, nail polish, like Grace mentioned. It can be saying, oh, you're transgender, you don't look like it. And it can also include asking someone to give you like a transgender 101 and answering a whole bunch of questions. Even though it's coming from a good and well-intentioned place. So I think the focus here and the message that we want to provide is that you want to avoid putting the onus and the burden on the other person to essentially educate you on everything that's transgender, asking loads of questions and making them educate you. The message here is it's a shared responsibility, and it's really important for ourselves to do the research on our end and show some real engagement in taking initiative to learn on our own. And what organizations can also do in that respect is help by providing training and education to their employees. So if we move on to the next slide, we're going to talk about education and training. So that can help employees gain some knowledge and understanding of key principles. You can help your employee base become supporters and allies of transgender and gender diverse employees. And by providing training to other employees, you're also supporting transgender employees by hopefully minimizing the number of microaggressions or other discriminatory conduct that they could be subjected to in the workplace. So topics that you'll see here in terms of education and training, it can include teaching employees about their unconscious biases. There's a whole bunch of kind of fun and scary questions that can be asked and that you answer and that you figure out a lot more about your own biases. It can help them develop their 2SL LGBTQI plus competency and knowledge. And it can help them identify what constitutes different forms of microaggressions in the workplace. If you're learning or interested in learning a little bit more about microaggressions, there's a Toronto firm that's called Zulu Alpha Kilo that created an online tool. It's called the Micropedia of Microaggressions. And it really outlines a series of comments that marginalized groups can face. It's organized in 9 different categories. So it has race, gender, disability, religion, a whole bunch of different ones. And you can click through to look at different examples of microaggressions. Now, obviously, you're probably already doing this 4th bullet here in terms of providing your workforce with training on violence, discrimination, and harassment. But going forward, what you should consider is really adding some specific information about the violence, the discrimination, and the harassment that's faced by transgender employees, and help your employees create safe spaces and inclusive spaces and environments for those employees and all employees. So what does that look like? It's really about encouraging employees to be curious and seek out perspectives that are different from their own. Encouraging employees to own their learning process, like I discussed, reflecting on their own identities, perspective, biases, their privilege, and really by educating themselves on the experience of others. It's about encouraging your employees to tell their colleagues they care about inclusion and ask for feedback towards their own improvement, encouraging employees to listen actively. We have a hard time with that these days, to really stop and listen actively and to use inclusive language without making assumptions about someone's viewpoints. It's encouraging your employees to check in regularly to try to better understand other people's feelings, challenges, and priorities, and by asking how best we can support them. The other thing you want to consider here is making sure that anybody that's going to be tasked with conducting workplace investigations, so I'm thinking HR representatives mainly, are trained on how to use the trauma-informed approach. So a trauma-informed approach involves having really a baseline understanding of the impact that trauma and violence can have on individuals that come and seek support. And it's about recognizing the signs and the symptoms of trauma in your staff. It's about responding by fully integrating the knowledge about trauma into policies, procedures, and practices. So the goal of a trauma-informed approach is really to minimize harm. It's not about treating the trauma, but it's about minimizing the potential for further harm. The trauma-informed approach can be used in a whole bunch of different settings. Really, the goal is to create an emotionally and physically safe space, foster opportunities for choice, collaboration, connection, because people who have experienced trauma can be impacted in how they remember or perceive events. They can be impacted in their ability to recount details of events. They can also be emotional and react in ways that the investigator may not have expected. So they should really be well prepared to deal with these types of situations. And I'll give you a simple example of what an investigator can do by using the trauma-informed approach is instead of starting by asking the person, why don't you start from the beginning? You could simply ask, why don't you start where you feel comfortable? It's also about open-ended questions when that's possible, trying to be neutral by inviting the person to help you better understand the situation and really empower the person by asking them if you've missed anything that they would like to add. So without a good understanding of the potential effects of trauma, your investigators could really come to an assumption that the person that they're meeting with, is either being evasive or unreliable because they don't remember all of the details, or because they're not giving their story in a linear fashion. And that's just not the case. And they should be aware of that and really be able to move forward with the investigation based on the information that they have. So we're going to move on. Again, talking about education and training, but whether this should be a proactive or a reactive approach. And you won't be surprised to hear that from our perspective, it's really essential to prevent, versus then dealing with damage control. So by providing training in advance, you may be able to prevent complaints altogether if you're lucky, or at least minimize the degree of seriousness of those complaints. Also, by proactively training your employees, you're really going to show your workforce that you're engaged in supporting a positive and inclusive workplace. Again, this is sending the right message to everybody involved in the workplace. And then by making sure that your executives, your HR representatives, and your managers are properly trained and alive to issues surrounding transgender and gender diverse employees, you're going to help them be good role models. You're going to help them set the tone to establish a positive team dynamic. You're going to encourage them to really think about and reflect about power imbalances and inequalities. And so they can seek out some input from team members who may be more hesitant to share their views. You can have your key management players lead with vulnerability and empathy by getting to know their teams, asking them to share their needs. And you can make sure that your management representatives really allow all members of the team to perform to their fullest potential, and not just those who look or act like them. So again, this is a key message that we're giving you. We're all learning. Nobody has all the answers or wisdom to deal with every possible scenario. And this is why your training should really be ongoing, not only proactive, but ongoing. Things change. Grace was telling you about terminology, how that changes as well. So your training should be ongoing as well. And that really by proactively dealing with training, giving education to your workforce, that there's really a collective goal there to learn and adapt to ensure that we have some safe and inclusive workplaces. And it's really only when we are willing to have courageous conversations, open dialogue, that we're going to be able to make some true progress towards understanding and greater inclusion. So let's move now to the next slide. And this deals with policies and physical spaces. So, we all know that actions speak louder than words, but what's written in your policies really has a big impact, because it can be incredibly empowering when every employee can see themselves in the official policies of an organization. It also adds weight and credibility to the verbal statements that your management is hopefully making elsewhere in other contexts. So what you say in your policies and your practices really send a vital message to your trans employees about their value as organizational members. So let's look at a couple of them so that we can have just some basic real life examples of what this can look like. If we deal with parental leave policies, you can review them to make sure that they reflect your commitment to transgender rights in the workplace by replacing mother, father with a gender neutral term like parent. You could even use the term caregiver to include the consideration for any other employee that's caring for a child, regardless of the relationship. Now, I want to pause here in having or reviewing policies and then changing the terminology for more inclusive language, because you have to be careful to make sure that whatever rights are afforded are still afforded to their intended recipients. And so, for example, it's not uncommon for employers to provide different benefits to the parent who bears the child than to all parents. And this is also the case in employment standards legislation that really makes a difference between pregnancy leave and parental leave. So again, when you're reviewing your policies to make sure that they include some more inclusive language, just make sure that you're doing it and still reaching the ultimate objective of the organization, and that that's still reflected in your policy. So what else can you do? You can review your handbook and your benefits policies to consider including gender neutral language by including they, them pronouns. Grace told us a little bit about drop-down menus. They can be great and they can be difficult. And sometimes the easiest approach, instead of having male, female, other, which really has the effect of othering the other group, is really to leave an open space and give the ability and the choice to the employees to provide the information that you have. But again, other examples that we had for mother and father, when we're dealing with benefits policies, it can be instead of having husband and wife, you can have spouse or partner. So I think the message here is that thankfully, a lot of workplaces have come a long way in terms of their inclusivity of diverse employees. There's still a long way to go. But there's a really long way to go in our experience anyway, as between Grace and I, when we receive some of these policies, is really to look at the language. And I want to pause here because I know that a lot of participants today on the call are French-speaking or Francophone participants. And I want to acknowledge that what I just discussed in terms of using more gender-neutral language has a particular complexity in the French language. I love the French language, being French, but it is, either feminine or masculine. It's inherently gendered and binary language, and it has a whole bunch of different rules that make it really difficult to revise some of these documents. So if you're interested in that from a French perspective, I'm happy to point you to the Government of Canada. They've published some guidelines and resources on inclusive writing. If you Google Canada Guidelines for Inclusive Writing, or in French, Écriture inclusive, lignes directrices et ressources, you're going to find a series of tools to help you in terms of using more inclusive language in French. Other policies that we have here, we're talking about dress code policies. Those can be relatively simple changes in terms of saying, skirts must be no shorter than 3 inches above the knee, instead of saying women's mini skirts are not permitted. It can be changing what are kind of gendered scents, such as cologne, perfume, aftershave, just changing it to we have a scent-free space. It can be changing blouse to dress shirt. So these are simple kind of changes that are easier to make in these types of policies. Another thing that we listed here in the second bullet is reviewing options with the insurer and the benefit provider with when it comes to coverage for gender-affirming care. This is such an important and difficult step in a person's life, and having coverage under a company plan can really mean the world of a difference for those employees. Here's another aspect on which we had a lot of questions, and it was the question of considering more inclusive office, physical spaces. And by that, we had lots of questions about restrooms. So our objective today is really not to politicize an already polarizing question. We know that different provinces take different approaches. For example, recently Quebec came out with a different approach in terms of washrooms in schools. But from our perspective, what you need to remember is that having gender neutral bathrooms and encouraging trans employees to use the bathroom that aligns with their gender identity is really an important way that you can signal to those employees that they're valued in the workplace. So again, no cookie cutter, one size fits all approach. You're going to have to look at your specific workplace and its physical space. And it may be that you still only have men and women's washrooms, and this can create some anxiety for employees who are transgender or non-binary. So you can consider removing them and changing all to gender neutral washrooms. But another option is also, instead of just replacing all of them, really having a third category where you'll have male, female, and then gender neutral and universal washrooms. These are helpful for many employees. They're helpful for transgender employees. They're helpful for families. They're helpful for people who use wheelchairs. They're helpful, frankly, for anybody who wants a little bit more privacy. So those are things that you can consider. Many of the questions that we received, I think I'm seeing some come in as well, is, how do you respond to what can be perceived as competing rights between the right of a trans person to use washroom that aligns with their gender identity, and then the right to safety? And we wanted to take a bit of time here to just share that in our experience, it's generally the trans employees that are at risk of harassment or violence in the context of washrooms, and they're not the perpetrators of that harassment or violence towards others. In fact, just going back to some statistics, because we always love a bit of statistics, they show that 70% of trans people have experienced some sort of negative reaction when accessing a public bathroom, and 57% of trans Ontarians have avoided using public washrooms when they have needed to go for fear of harassment. So again, depending on your specific workplace and workforce, it may be best to just start with adding a third category, and really with the goal of ensuring that as many people as possible feel safe. So that leads us to considering, what can you do in terms of putting in place new policies that can deal with the issue we just discussed in terms of having a restroom or washroom policy that would make it clear to all employees that they can use the restroom of their choosing, and that's associated with how they identify. You could consider putting in place pronoun policies. So that's really to explain the purpose of pronouns, which is to recognize employees and how they like to be addressed and referred to. It would explain that this is a sign of respect. And that, frankly, employees have the right to be addressed with their correct pronouns in the workplace. The policy could suggest to use gender-neutral pronouns like they or them until the true pronouns or preferred pronouns are known. And typically, these types of policies will also allow employees to use their pronouns and indicate their pronouns in their signature block or office name tag, et cetera. So it's really clear from our conversations, our research, and the cases we're going to discuss that misgendering of trans employees, whether it's intentional or not, is relatively common at work. So having this type of policy can be very useful. And frankly, if this is new to your workplace, you're going to have to train your employees on it. Language really does matter. Grace told us about terminology, and employees should be encouraged to ask when they don't know which words to use. They should realize the terminology is evolving. And frankly, the best approach is always to ask, listen, actively listen, and then comply with the request that's been given. Nobody's perfect. We all make mistakes. If we make a mistake, I think the important thing is really to have the humility to acknowledge it, apologize, learn from the mistake, and move on. So that deals with pronouns. If we move now to the third bullet here in terms of employee resource or affinity groups policy, that's something else that you can consider putting in place in your workforce. It's really about creating the opportunity for employees to know that they can gather in safe spaces and create a community where their members and their allies feel welcomed. Grace is part of our Pride Network, and it's really brought members and allies together for nearly a decade now. The objective is really about fostering inclusion, understanding, increasing representation, and retention. So these are good things to have and to signal to your employees in terms of the ability for them to create these affinity groups. Moving on to the next slide. And this was also something where we had a lot of questions in advance of the presentation in how to deal with, we call it here return to work for gender diverse employees, but it really has to do with accommodation. So on that, I think there are two things that main principles. Accommodation is going to be the same for all employees, right? As the employer, there must be accommodation to the point of undue hardship. That's not going to change. What does change is just the particular considerations that are involved for gender diverse employees who are returning, for example, from having gender affirming care. This is not a single event, it's a process. And it usually is the result of years of soul searching. It's not something that's easy, and it needs to be handled appropriately. So preparation is going to be key. You're going to want to review your policies that we just discussed in advance with all employees. This may also be a good time to update those policies like we discussed. You want to ask the employee for their input before and after the return to work. So you want to deal with correct pronouns, forms of address. You want to get them engaged. You want to hear from them as to what can be done to best support them. They will have input, follow their lead, ask questions. One of the important parts too here is really identifying a person that's your point of contact. So that they can deal with any issues down the road, and they can be an easy resource for the employee to go back to and ask questions when they have questions. It's really about kind of having those regular touch points moving forward, asking questions. How are things going? You want to avoid using the employee's dead name, even when referring to a previous time. In doing that, you're going to have to review your company documents, your forms, your email, just to make sure that everything is in order from that respect. And you're going to have to remember that you should be expecting a longer, perhaps even more gradual return to work period. So as I mentioned, these are pretty important steps in somebody's life, and they're not going to be done in a matter of weeks. It's going to take some sort of process, and they're going to feel like they need special type of support during that period. So those are things that you have to remember. It is, accommodation to the point of undue hardship, but with particular circumstances that need to be taken into account. Realities of them having ongoing medical appointments, having their immune system affected by the care that they received. And so that may lead to more and more frequent illnesses, just things that you need to have in the back of your mind when you're dealing with gender diverse employees and their return to work and accommodation measures. So we're going to move it on. I think we're doing pretty well for time. We want to take a little bit of time now to talk about lessons that we can learn from the case law. And Grace is going to start from that perspective.
Thanks, Judith. So our first case is Bilac and Abby Courier and NC Tractor Services This was decided semi-recently in September 2023 from the Canadian Human Rights Tribunal. So Bilak, a transgender man who uses he, him pronouns, was assigned another name at birth, which he had not been able to legally change. Now, he essentially moved provinces to take up, for employment reasons, a new job. And he was not out as being trans in this new community that he moved to, which it's important to note. I know it's a lot of specific background. This was a very small town that he moved to. So throughout his employment in this small town, he was repeatedly dead named, misgendered, and asked invasive questions about being transgender, which did include receiving questions about which washrooms he uses, why, where he would be using a different washroom, just a number of questions about how he uses the bathroom, essentially. Bilak resigned from his employment and subsequently brought a complaint with the Canadian Human Rights Tribunal. The complainant alleged that the respondents refused to use his correct pronouns and name, instead misgendering him and dead naming him consistently. He also alleged that even after educating his employer, the respondents, which there was a number of individuals named, including the business owner, about the potential dangers of being outed as a trans person in a small town, the business owner continued to do so. So feeling that his dignity, safety, and privacy was not being taken seriously, he elected, as I mentioned, to quit his employment, to resign, and filed this complaint. A couple things to note. During the hearing of this matter before the Canadian Human Rights Tribunal, the respondents, all of them, continued to misgender and dead name him during the proceedings. So that was made specifically of note in the decision, that even after the tribunal member indicated that was not the correct name or the correct pronouns for the complainant, they continued to do so. So in the tribunal found that the respondents had acknowledged that they misgendered and dead named the complainant, but continued to do so. And they also, the key point being here, they also misgendered, dead named, and basically outed the complainant to other individuals, not employees of the company, but to members of the community. So essentially, in reading this case, it seems like members of the community would come and kind of hang out. It was casual, so would hang out in the office. Like I said, they weren't employees; they were friends of the owner. And in casual conversations that the complainant was at, his employees and the business owner actually outed him to those individuals within the community. So the tribunal, in their decision, basically released a number of findings, which included that they cannot out him to the community, particularly in the instance that it puts his safety at risk. It's a small town. So that kind of, as we mentioned before, going into what the employer should do, not outing someone in the community, not just within the workplace, within other employees, but expanding the scope as well. So the tribunal also found that the complainant's loss of employment was a byproduct of feeling like he had no other choice but to leave the workplace after trying to educate his employer. And the misgendering and dead naming was adverse treatment with respect to his employment. So the tribunal awarded the complainant $18,000 as compensation for injury to dignity, feelings, and self-respect, accepting that the respondent's consistent behavior favored what they called a higher award. Notably, the tribunal accepted the complainant's fears for his safety in the community and in the workplace, and for future discrimination, particularly within the community, as a result of the treatment he faced. And the tribunal described the behavior of the respondents as reckless. So $18,000 awarded for injury to dignity and feelings. Judith, you're up next.
Thank you. Okay, so this next case is from the British Columbia Human Rights Tribunal. Jessie Nelson, a non-binary, gender-fluid, transgender person who worked as a server in the restaurant Goodberry that was operating under another name, again in a small town. Jessie's pronouns are they, them, and the bar manager refused to address Jessie using the proper pronouns. He also used demeaning nicknames like Sweetheart, Honey, and Pinky because Jessie's hair was originally pink. Jesse asked the bar manager to stop, and he did not. So Jesse sought the assistance from the other two restaurant managers. Eventually, there was a heated exchange between Jesse and the bar manager, and Jesse's employment was terminated only 4 weeks after having started working at the restaurant. The respondents took the position that Jesse was terminated without cause during their probationary period. They also explained that Jesse was the first non-binary person to work at the restaurant, that this was a new experience for many of the staff and managers. So the tribunal had to look at 3 questions here. Was this discrimination? Was the employer's response to the concerns that were raised by Jesse reasonable? And was Jesse's gender identity and expression a factor in their termination? So on the next slide, we will see that in coming to their conclusion, basically that yes, Jesse had been subjected to discrimination. And I want to take a few minutes here to discuss some important observations that were made by the tribunal. The first is that using correct names and pronouns is not an accommodation. It's a basic obligations towards people in their employment. The tribunal recognized, and we talked about this, both Grace and I, that many people are still working, right? They're working to undo what the tribunal called habits of a lifetime, and that despite best intentions, people will make mistakes, regrettably at the expense of trans and non-binary people. The tribunal notes that human rights law, however, is not concerned with intentions. It's concerned with impacts. This doesn't mean, however, that the intention is irrelevant. And the tribunal takes some time to say that where a person is genuinely trying their best, acknowledges and corrects their mistakes, the harm will generally be reduced. The difference here was that the conduct of the bar manager was careless. It was deliberate. So it was no defense to him to say that he was older, he was old-fashioned, or he was confused. What the tribunal clearly stated was, though he may have struggled to adapt to a new way of thinking, he was obliged to at least try. So if we move on to the second question that had to deal with the employer's response to the situation, the tribunal in this case found that it fell short of what was reasonable and appropriate. In the tribunal's view, the response lacked a sense of urgency. So what had occurred is that, as I explained, Jesse was going to the bar manager himself, who refused to stop using the wrong pronouns, and then went on to talk to the other two restaurant managers. And then those restaurant managers asked Jesse to wait. They told Jesse that they were dealing with other performance issues for the bar manager, and they just didn't want to pile on too much on him. So the tribunal clearly stated that, and I quote, "Whatever the manager's other performance issues may have been, his duty not to discriminate against a coworker should have taken immediate and urgent precedence." So of note to everybody that's on the line today is also the comment about if it was truly necessary. So saying, okay, let's say it was truly necessary that we had to wait before dealing with this matter, then the employer should have put something in place to protect Jesse from discrimination. So this goes back to making sure that HR professionals in the workplace, when they're confronted with these situations, that they really consider whether interim measures are appropriate to protect the people that are in the workplace. So dealing next with whether Jesse's gender identity and expression was one of the factors that led to the termination, the tribunal found that it was. It noted that from a human rights perspective, it doesn't matter that Jesse was still on probation. Employees are still protected from discriminatory conduct even while they're on probation. The tribunal explained that when an employee is terminated in the context of a discriminatory work environment, you need to pay careful attention to the situation to make sure that there's no connection between the termination and the discriminatory environment. So here the tribunal quoted from another case to state that the expression of anger is a completely appropriate and healthy response to discrimination, which emanates from a sense of self-worth and a demand that others recognize one's humanity. The tribunal found that the restaurant failed to put Jesse's heated response to the bar manager's comments in context. The restaurant couldn't ignore the inequality between the two sides in the conflict and its connection to Jesse's gender identity. So in short, the tribunal found that Jesse was terminated because of how they responded to discrimination, and they were held to a higher standard of conduct than the bar manager, and the discriminatory context of the dispute was not taken into account. The other important finding that I thought was important to mention to all of you here today on the line is really that when Jesse was asking the manager why their employment had been terminated, they kept referring to the probationary period, but ultimately they said this. They said that Jesse had come off too strong, too fast, was too militant, and that staff wasn't there yet. Jesse did not vibe with the team, and that they were not a good fit. Well, here's what the tribunal had to say about that. This situation demonstrates the dangers of fit or workplace vibe when it comes to equality-seeking groups. Jesse Nelson was the first trans non-binary employee to work at this restaurant and to insist on equal treatment. They did not fit in with employees and managers who felt uncomfortable and challenged to change behavior they had engaged in for their entire lives. Ultimately, the employer concluded that it would be easier to terminate their employment than to meaningfully address any of these issues. In doing so, they discriminated against Jesse. So Grace told you about a case where it was $18,000. In this case, employee was hired for 4 weeks, $30,000 awarded against the restaurants and the 3 managers individually. The tribunal also ordered the restaurant to implement a pronoun policy that we discussed and mandatory training for all staff and managers about diversity, equity, and inclusion. It also encouraged, but didn't order, that the restaurant review its policies to use non-binary, gender-neutral language throughout, as we also discussed earlier. So over to Grace to discuss our next case.
Thanks, Judith. So similarly, this is Ian and Gallagher's Bar and Lounge, 2021 Human Rights Tribunal, Ontario 240. These were 3 applicants who were kitchen employees at a restaurant, each identified as either genderqueer or non-binary, using the chosen pronouns they, them. They openly addressed or requested to be addressed with these pronouns. The applicants alleged that despite the request, the owner refused to use their pronouns, instead repeatedly misgendering them and saying that he had to walk on eggshells. As well, the applicants overheard the owner, Mr. Gallagher, speaking with customers out in the open dining room and bar area, referring to the kitchen staff with a transphobic slur, which I won't repeat, but it is on the screen. And I did note that we had a question about what was the second term to not use any further, and it is somewhat related to this term, and that term is transsexual. So we no longer use that term or the abbreviation on the screen. So when the applicants raised their concerns over the owner's transphobic comments and misgendering, Mr. Gallagher denied the slur and claimed he had told the customers that he had 4 staff who were LGBT. He refused to acknowledge or address their concerns or to implement any workplace changes. So as a result, the applicants considered this to be a form of constructive dismissal, feeling like they could no longer continue their employment with the bar because they did not want to risk an experience or recurrence of the personal respondent's conduct or the consequences of his disregard for their privacy and safety. So they brought this complaint to the HRTO alleging discrimination in employment, contrary to the code, against both the restaurant and his owner, Mr. Gallagher. Neither respondent the restaurant and the owner, responded to the application, but the allegations were then therefore deemed by the HRTO to have been accepted by the respondents, and the decision was based solely on the sworn affidavits and written submissions of the applicants. So the tribunal held that the applicants experienced adverse treatment in the course of their employment based on their gender identities, gender expressions, and sex. It affirmed that genderqueer and non-binary trans people are a historically disadvantaged group protected from discrimination under the code. The tribunal considered the abbreviated reference term that was used as being a transphobic slur and found that its use by Mr. Gallagher in a public setting to the bar's customers effectively outed the applicants in a derogatory and non-consensual way, causing them to fear for their safety. So this is very consistent with what we saw in Bilac, decided just 2 years after this. The tribunal found that Mr. Gallagher, in refusing to acknowledge the concerns, was dismissive, and rather to address the situation and respond appropriately. He implied through his comments that they were being overly sensitive about his refusal to address them in accordance with their chosen identities. The tribunal found that in misgendering the applicants in these ways, they were subjected to adverse treatment. The tribunal did find that their resignation or loss of employment was a byproduct of feeling like they had no choice but to leave the workplace that refused or failed to respond to their concerns out of fear for their safety. And the tribunal described this as shocking and hurtful. So ultimately, the bar and the owner were found responsible, and the tribunal awarded the applicants $10,000 each, similarly as compensation for injury to dignity, feelings, and self-respect. This was also described as being a higher award, but importantly, the tribunal accepted that the owner's misgendering and intentional use of improper pronouns, the key being intentional, constituted discrimination. Judith, on to you for the next one.
Great. So we're moving back and forth here from jurisdictions. We're going to head back to BC for another case of the Human Rights Tribunal there. Recent decision from late January of this year. Mr. Glebov was terminated after posting YouTube videos preaching transphobic views. He claimed religious discrimination and filed a human rights complaint against the Fraser International College. And the college here, in terms of preliminary step, applied to have his complaint dismissed on the basis that there was no reasonable prospect that Mr. Glebov's complaint would succeed. So the tribunal here had to determine two questions. First, whether publicly sharing his views about abortion, sexual assault, homosexuality, gender identity, and various non-Christian religions forms part of Mr. Glebov's sincerely held religious beliefs or practice. And secondly, whether his ability to practice his religion would be compromised if he were unable to do so. Ultimately, the tribunal rejected the complaint at the preliminary stage. So by way of background, who is Mr. Glebov? He was an academic sessional instructor in the math department of the college. His employment agreement referred to various rules and regulations of the college, which included topics on harassment, termination, conflicts of interest, and code of conduct. And at some point, the college received an anonymous email informing them about the videos posted on YouTube by Mr. Glebov, and which expressed various views. There's 11 topics, again, clearly transphobic. I won't need to repeat them, but essentially the college informed Mr. Glebov that his videos went against college policies and suspended his teaching duties while continuing to pay him for the rest of the semester. The college then put in place an investigation to assess the impact on the student population and ultimately terminated the contract that Mr. Glebov had signed for the following semester. So in assessing the matter, the tribunal explained that a dismissal application is not the same as a hearing. All the complainant had to show to be allowed to pursue his matter to the hearing stage was that the complaint was not in the realm of conjecture. Essentially, the college conceded that Mr. Glebov had experienced an adverse impact, obviously, when his employment was terminated, but argued that Mr. Glebov could not, he would not be able to establish that his conduct on YouTube arose from a sincerely held practice or belief that had a nexus with his religion. And the tribunal agreed, because Mr. Glebov had not provided any basis for stating that publicly disseminating views is related to the tenets of his faith or that his ability to practice his religion would be compromised. So essentially, the question was posting YouTube videos, or did posting YouTube videos engage his ability to practice his religion? The tribunal noted that the sincerity of a complainant's religious belief is a question of fact based on their credibility and factors such as whether their alleged belief is consistent with their religious practice at the material times. The tribunal here, interestingly, contrasted another case in which a complainant there had shown a link between distributing a flyer containing views about transgender people and the complainant's religious beliefs. But here, there was no such evidence linking his conduct of preaching views about transgender people on YouTube to his religious beliefs. So the complaint was dismissed. I think this is an interesting case, and I'm just mindful of time because Grace also has another one, but it has to deal with competing rights. And so when you're faced with competing rights, just remember to pause because there needs to be a consideration as to whether the other person's right is actually engaged, and here it was not. So Grace, over to you.
Yeah, I know we have lots of great questions that have come in through our presentation, so we'll try to get to a couple of those as well. So this is the Ontario English Catholic Teachers Association and Northwest Catholic District School Board. Very recent Labor decision, and this decision is primarily about ensuring discipline is measured and education on the issues is at the forefront. So it's about taking a step back, completing an investigation with respect to, having the policies we've talked about in the back of your mind, and then making a measured decision and ensuring that discipline is measured. This was an occasional teacher who was terminated after she accidentally, and accidentally is in air quotes, but it was without a doubt an accident that this email was sent. It was meant for one person and it was accidentally sent to the entire teaching staff. And the email was characterized by the board as homophobic and hateful, as well as contrary to its views of inclusivity, acceptance, and love. The griever argued her statements were consistent with the Catholic Church's view onto us LGBTQI+ on the community. As Judith mentioned, we got to take into account the balancing of rights. So there was a large discussion on the fact that it was an accident, the fact that it was meant specifically to go to one person, so not truly to anyone. The griever was putting forth what she felt like were her sincerely felt beliefs. She didn't mean any harm with respect to literally anyone receiving it, first and foremost, but for people to know what she felt, it was meant to be quite personal in just sharing her views. So the arbitrator took that into account because the termination happened very quickly. It was almost a matter of about a day, maybe even less, that she was terminated. So the arbitrator said, look, we got to step back. We got to take a look at the whole picture. We have to talk to this person. We have to, understand where they came from, confirm, why they did what they did. So the arbitrator replaced the termination with a time served suspension. So still upheld some type of discipline, some type of suspension, and added that there wouldn't be any back pay. He held on the basis that it was an isolated incident. The griever understood the gravity of her words and was apologetic. She promised to be more circumspect moving forward. Like I said, it wasn't intended to go to every teacher, and the arbitrator found that it was highly unlikely the griever would engage in similar misconduct again. So good to keep that in the back of your mind. A new case, be measured, do your investigation, have it be trauma informed, and then make any discipline on that basis. Like I said, on that basis. So Judith, do we have time to get to a couple questions?
I think we do. I think we do. There's been some great questions, so we're going to try to get through as many as we can. The first that I'm going to address, because it's quick and easy, there was a question about repeating the website for microaggressions. So it's called the Micropedia, like encyclopedia, but the Micropedia of Microaggressions. So that takes care of one. Grace, question for you that's coming up, and it's really um, what should you do if someone is accidentally misgendered at work, like in real life?
Yeah, I mean, as well, I think we've talked about through the cases, the occasions where it was intentional, right, or reckless. However, when someone makes a mistake, as we all do, as we both do with language, sometimes we can trip ourselves up. The first thing, you want to correct yourself, or maybe that person's going to correct you because maybe you don't know that you've made a mistake or said something incorrectly, and that's absolutely okay. So to correct yourself, or if someone says, "Oh, actually, it's she," say like, yeah, thank you for letting me know. Like say she, or if that's the case, you don't want to make a big deal out of it. I think that we oftentimes kind of unfortunately we feel bad, and we might put that emotional burden on the person that we may have misgendered or misspoke towards. So just taking accountability super quick. The person that you've misgendered is not going to want a massive conversation, is not going to want it to be made into a big deal, especially if they just said, "Oh, it's actually I use she/her pronouns." So like, "Oh, thank you so much for letting me know." It's absolutely okay to feel like you're going to make a mistake again. I think it's just about the accountability and to just move past it. Don't let it hang in the air. Don't let it be a really long time. Don't go "I'm so sorry. Oh my gosh, that's so embarrassing." Make it short. And just do your best moving forward.
That's great. Thank you. So another one coming up for pronouns. With pronouns, is it the employer's responsibility to communicate the preference, or is it the employee's?
Yeah, so I think it's always helpful to have a pronoun policy, which kind of just, as you mentioned, sets the standard for, you're welcome, obviously on a voluntary basis. You're welcome to put your pronouns on your signature block. I think it's difficult with language, particularly in French, as you mentioned, Judith, to know how does someone want to be referred, right? But it is okay to always ask, just to say, "Hey, like Judith, I use she/her pronouns. Can I ask your pronouns?" And then Judith, you'll say, "I also use she/her pronouns," right? So if you don't know and you want to get it right, that's great, right? So like, I really want to get this right. Just a quick question: what's your correct form of address, right? Is it Mister? Is it Miss? Is it Mix? And like we've talked about before, pronouns can change, they can evolve, forms of address can change, but it's okay to inquire, to say like, "I want to get this right. How do you want to be referred to?" Because it is hard to use. It's not the easiest thing to never use pronouns in a conversation. And I think Judith and we're not recommending that to any of you, to try to use like insert they in every part, but to just make like, "Hey Jess, just want to check your pronouns. I just want to get it right. And I'm about to introduce you to Mark. How would you like me to introduce you with respect to your pronouns?" Because that's something we do in this workplace. It's totally okay. I just want to make sure that everyone feels comfortable, right? Not making it about that person, but saying like, usually we include pronouns in our signature block. So if you feel like you want to include yours, go ahead, but making it a voluntary part of the process.
Great. Thank you, Grace. Actually, on that, I remember another one of the questions was about the signature block, and somebody asking whether not having the pronouns there could send the wrong message. Do you have any input on that, Grace?
Yeah, I think that a lot of people kind of assume like, "Oh, well, I look a certain way, so it's obvious," right? And I think our answer to that is a gender expression. It's such a spectrum. Nothing is ever considered obvious. So a lot of what people can do, if their pronouns align with their gender identity, that's great, right? We never want to force anyone to use pronouns in the context of a workplace, particularly when they're not needed. A lot of people who are allies, they'll say, "Hey, my pronouns are she/her. We're just going to go around the circle and share our pronouns just to make sure that we're referring to people correctly." But it's absolutely okay to just elect to not share your pronouns, right? It's a personal thing. You can also, for people who are conscious of their own pronouns or questioning them in the moment, just say like, "Oh, Grace is just fine. That's it. That's all. You don't need to say like, oh, well, I'm really going to need to associate a pronoun with your name. Oh, like, can you just call me Grace? Or you can just refer to me as Judith, or Miss McDonell is fine too, or McDonell, or counsel. So no reason why you have to, force yourself to include pronouns in a signature block, or we would never suggest that that's a requirement that you do for your employees.
Thank you. All right, so there's lots, but I think I'm going to go with one last one, and I addressed this a little bit, but maybe Grace, from your perspective, so that we're being asked for some practical examples of accommodation measures for an employee who is trans.
Yeah, I think as you talked about, particularly in the context of like returning to work, if they have a first day back and they've maybe undergone some physical changes, it's just leaving it open to kind of let them lead the way. If they don't want to have a massive welcome back party, that may be very overwhelming for them. So I think a lot of it is just touching base with that employee who's returning to work, who you would touch base with for any return to work, regardless of the circumstances. Accommodations with respect to, there is a greater likelihood that person might have more medical appointments. So just making sure that, of course, they're still following the procedures and policies for saying, hey, I have an appointment from 2 to 3 p.m. What is your workplace policy? We need you to provide, us with just some notice, like the day of or the day before. So of course your procedures need to remain, but understanding they may need time for appointments, greater recovery time if they're undergoing any gender affirming steps. And yeah, of course, knowing, like with respect to accommodations, just knowing that it's important that you identify who their point person is with respect to HR, with respect to their manager or their supervisor, so that they have they know who they can go to, and with respect to any complaints as well. I don't know if you have anything to add there, Judith.
I think that touches the high points, and that's great. So I'm seeing that we've come to the end of our time today. I want to thank everyone for joining us. On your screen, you're seeing 2 QR codes. One is for our survey, and the other one is for the Ontario or Quebec CPD certificates. Links to both have also been added to the chat. So for our BC viewers, the Law Society of BC title has been added to the chat as well. A little plug here, our next LEHR webinar will be held on May 23rd, and it's titled Pants Optional, New Issues in Remote and Hybrid Work Arrangements. The invitation for this event is going to be sent soon. Please keep an eye out on your inbox and visit the Fasken Institute section on fasken.com for all of our upcoming events. Thanks again, and have a great afternoon.